welcome to the Personal Injury Law Show. This show that talks about everything current in the law of personal injuries and relevant to you, the viewer. My name's Tony Carbone. I'm a personal injury lawyer with 30 years experience. With me tonight I've got Nunzio Tartaglia, a partner in a law firm in insurance work. Good evening, Nunz.
Good evening, Tony. Viewers, welcome.
And an up-and-coming star in the law in insurance work, Jessica Rosla.
Good
evening, Jess.
Evening, Tony. Evening, viewers.
Viewers, tonight we're going to give you an update on what's happening in the law of insurance.
Before we kick off though, Tony, what's in the news?
Well, there's been a lot of stories, but the one I want to touch on at the moment, Nunz, is a case that you're involved with. Give us the facts of this parachutist that jumped out at 14,000 feet.
Yeah, look, Tony, this is a client of mine in the firm, and you probably would have seen a double spread over the Herald Sun recently, so it's been big in the news. And yeah, client received a voucher to go skydiving, and obviously he was in tandem, so he had an instructor with him. And unfortunately, on the way down, the main chute didn't release properly, and then the backup chute effectively released too late and got caught up with the main chute, and he hit the ground, and I think they've estimated about 70 to 80 kilometres per hour. So, look, hit water, but likely to be alive.
That's probably what saved them. Jess, the emergency chute opened at 500 feet, but then tangled up with the main chute. Our client asked the tandem jumper, "Are we going to die?" And what was his response? I don't know.
Yeah, that's...
How would you feel? I don't know. That's insane.
Oh, look, when you hear and read the actual version of events and what he went through on the day, it's almost could be about a movie, Tony.
I reckon I should do a movie out of this. Jess, he's got some big rights available to him.
That's right, Tony. I mean, certainly when you're partaking in these types of activities, there's some kind of accepted risk that you take on. But I mean, what's interesting about this case is that the Australian Parachute Foundation initiated a report in response to, I think, the legal proceedings on foot. And they've found that there's been about 11 incidents over 8 months involving similar circumstances.
What's bizarre about this nonsense is that the fellow that packed the chute had 4 previous matters where the chute had failed open again.
Yeah, and that's why the VWA or WorkSafe have taken this company to VCAT, and they've issued improvement notices, and it's going to be an ongoing issue. And look, I don't think it's the last we've heard of this, and look, it's a big story, Tony.
And why would the guy that packed the chute and made 4 mistakes have another 3 chances? That's what I can't understand.
Well, that's another relevant consideration. I mean, you'd imagine after one incident, someone would have picked up on it and not taken the risk again.
And Nunz, big claim for loss of income, medical expenses and pain and suffering. Yeah,
and also, Tony, Griffiths and Kirkhamire, which is basically home help claim. The fact is, he's, even though he was only in hospital for about 3 or 4 days, amazingly, he's been home ever since and requires ongoing care, and that also could form part of the claim.
And viewers, what that means is that if you've got someone assisting you at home, family member, things that you'd normally do for yourself, you can charge $30 an hour roughly for every hour that they're required to help you. So it's pretty big. Yeah. Let's move on to this candidate the Labor Party's put up to sit in Frankston in that troubled seat of Mr Shaw.
Yeah, that's right.
She's got bullying claims levelled against her.
Yeah, interestingly, this Helen Constance, who was earmarked by the Labor Party to take over Jeff Shaw's seat in Frankston, she was also working at the Peninsula Community Legal Centre for 30 years, Tony, but now a claim's been brought against her for bullying by her personal assistant.
And she was head of that centre for 10 years.
Yeah.
And WorkSafe settled a claim by the person that brought it against her.
She obviously, this personal assistant who she allegedly bullied, obviously made a work cover claim, and then by the sounds of the articles, has issued a common law claim in the Supreme Court, and that's settled. And look, we're not sure of the terms of that settlement, but it's confidential. But clearly, it was big enough to take an action to the Supreme Court, Tony.
It's a pretty mal-aligned seat, this Frankston, isn't it?
It is, it's controversial.
Between Mr Shaw and this particular lady. I think we should put up a hand and probably stand for it ourselves.
I know John Carantis likes his politics. Maybe he could...
Now, let's keep moving. Court told of mum's death alert. Hey, this is a lady that wanted to have the home birth, Jess.
That's right, Tony.
And she'd had a previous complication with her first birth.
Yeah.
Give us the facts.
Well, in this case, Tony, the mum was warned about 4 times by her doctor against the home birth, but notwithstanding the warnings, she still went ahead with it. And my understanding is that the birth went fine, but it wasn't until an hour after delivery that she started to hyperventilate, and she said to her midwives, "I'm dying, take me to hospital."
And what happened, huh?
Well, look, initially they didn't react, but then I think 5 or 10 minutes later they thought it's not getting better and they called the ambulance. So, look, Tony, the way I look at this article, the key is, you know, for this case to go anywhere, what did that delay cause by way of obviously the ultimate death?
Well, it's
That's the
before the
question.
coroner now, and it's a pretty tough case. And the thing is, 3 general practitioners from the same clinic she saw, and she was warned about the risks of the home births, and on 4 occasions underwent blood tests, and she was also anaemic. So her risks of having complications were pretty high, weren't they,
Yeah,
Jess?
most certainly. And I think the other tricky thing is that my understanding is that midwives who undertake home births aren't actually covered by insurance schemes. So I'm not sure how this is going to go. But
Well,
stay
obviously
tuned.
that poses trouble. If there is a finding against these midwives by the coroner's court, even a potential civil case might not go anywhere because there's no money to
That's
to
right.
give. So.
Yeah.
Is it too far-fetched to be launching a proceeding against the GPs for not insisting that she didn't proceed with a home birth?
Look, on viewing of the article, Tony, I would have thought she's been, notified of the risks and on numerous occasions, and I would have thought she's accepted that and that the GPs are absolved of any responsibility. But just from my viewing of the article, anyway.
Why would she insist on a home birth? I mean, what's the magic in all of this?
I'm not sure, Tony. Obviously, I can't speak for her, but I'd imagine that it's a different type of experience. But certainly it's not one without risk. I mean, you can't have the same equipment and expertise that you would get at a hospital, so...
I don't personally see the benefit of considering it's such it's a dangerous exercise
Yeah,
you're going through. I think you want to be around hospital and qualified medical practitioners. But
Yeah.
She's giving birth is wrought with all sorts of risks. Why wouldn't you want to be in a hospital where you've got all the facilities and support? And even when you've got all of that, things still go wrong, don't they?
Exactly right.
Cancer survivors get legal support. Tell us a bit about this.
Yeah, so the state has introduced a new helpline for cancer survivors. In terms of more insurance issues and superannuation issues. And look, it's a great initiative, Tony, because as we know, there's not a lot of help out there for cancer survivors like this. And I think they're expecting to get about 600 calls in the first year.
Yep.
Look, I don't think it goes far enough in terms of if you're not getting access to your rights, but it's a great start.
And Jess, this is on the back of people that have, been diagnosed with cancer, going to the insurance companies and saying, look, I want to access my benefits, and they turn around and saying, no, you're not going to get them because you failed to disclose this and this.
Yeah.
So this group is supposed to support that.
That's exactly right, Tony. I mean, I think it's a great initiative that's been introduced by the McCabe Centre and the Cancer Council, and they ought to be commended. And often patients in these conditions are left to deal with a legal minefield. So I think it's great that they're receiving support.
Ultimately, though, look, I do say to these, cancer survivors and patients that you need to still see a lawyer, though, because I said, it goes further than that, Tony.
Nunz, we've got to go to a sponsors break, and I couldn't have said it better. Seek the advices of a lawyer. Stay tuned. Viewers, welcome back to the show. Today we're going to give you an update on some very interesting cases that no doubt you'll find very relevant. The first one, Jess, matter of Adisha and Banazi. It's a duty to warn case. Can you give us a background?
Yeah, sure, Tony. This case involved Miss Adisha, who consulted her gynaecologist, Miss Benazzi, for abnormally heavy bleeding. Shortly thereafter, having been prescribed a certain drug to treat the bleeding, she presented to the hospital with symptoms that were ultimately diagnosed as multiple pulmonary emboly, which is blood clots in the lungs. And then she brought a claim against her gynaecologist, noting that she failed to warn her of the risks of the medication causing blood clots.
And Nunz, what did the court find?
Well, obviously, initially it was issued in the Supreme Court, and the plaintiff failed in this instance. And then,
So in the first instance, the court found that the doctor had warned her of the risks.
well, what they found was, one, she could not prove that this medication has led to the ultimate damage, which is the blood clotting.
Yep.
And secondly, that even if she was warned of the risk, that she still wouldn't have taken the medication.
So she wasn't believed on that point.
Look, there must have been a credibility issue, Tony. You and I were talking about this offset, because if you give evidence of the fact that, look, I wouldn't have taken the medication, most of the time, wouldn't you think they'd be believed?
You'd think so.
Yeah.
Unless it shows up in one of her notes that she hadn't complained about anything. Jess, I agree with Nunzio. I think she was very unlucky that she wasn't believed on a balance of probabilities that she wouldn't have taken the medication. But what about the fact that, she had to establish the causal link between the medication and the problem with the embolism? Should that have been that complicated on all the...
Yeah, look, I think that often is a complication with medical negligence cases. In this case in particular, I think there wasn't enough objective evidence to say that the small risk associated with taking the medication actually caused the blood clots.
And look, at an issue with this one, from what I understand, is that she was self-represented for most of this proceeding. And so, look, I think it's just a lesson to viewers. Medical negligence and all sort of insurance cases are difficult and does require the expertise of a lawyer, because it's a minefield, Tony, as you know. And
It is.
it's hard for lawyers sometimes, let alone lay people. So,
Well, on a balance of probabilities, if all these complications occurred straight after medication, if you had the right representation, you might have tipped it over, don't you think, in your favour?
Yeah, I mean, as you both know, part of establishing that causal link is getting doctors in with the relevant expertise to make comment on that. So obviously as lawyers we have cases of a similar nature, and we have references where we can refer our clients to. So
yeah, and this particular reference to legislation she got approved, and she probably wouldn't have been aware of that, I would have thought, most likely. So it just, you've got to go see a lawyer.
But also, do you know when you take medication, there's the warnings on the inside? There's probably something on the inside saying, it could cause the problems that she encountered.
Yeah.
Don't you think?
Yeah, well, the court found that I think this risk was about 1 in 1,000.
less than 1 in 1,000,
and said that, would have that caused the damage? Well, we don't know. So.
Yeah.
Well, that's not enough to knock it out completely.
No.
No. And also, the moral to the story, viewers, is that if you take a medication or whatever description, ask the doctors if it could cause complications, and for the medical practitioners, be very wary to warn, because that's enough to get you to go down in a claim like this. Is that the moral to the story?
Yeah, most definitely.
Yep.
Yeah, certainly the court did raise that point.
And look, by reference for viewers, she did appeal, and unfortunately she didn't win on an appeal either.
On both
so,
counts.
she lost
Unfortunately
both
not.
times.
This is a very interesting case of Caruana and Durruti. Now, that's a self-represented plaintiff, Nunz.
Yep.
And Jess, this is a defendant that did her own work in the driveway.
That's
Do you want to
right.
give us the facts of this case?
Yeah, certainly. So in this case, Tony, Mr. Rudy slipped and fell on a driveway of the occupier's home. Interestingly, the occupier didn't own the home, but she had undertaken works on the driveway where she sealed the driveway twice in the past but failed to include an anti-slip additive to the sealant, causing the driveway to be slippery when wet.
And what happened there, Nunz?
Well, proceedings were issued in the New South Wales Supreme Court, from what I understand, and the plaintiff was successful and was awarded damages of $121,000. Terry.
And it was appealed again?
Appealed again, and it was effectively the defendant lost the appeal, and that damages award was upheld.
So, Jess, what should the defendant have done in this case?
Well, Tony, I think the court raised that she could have taken further precautions, including maybe getting an expert to seal the driveway or following the manufacturer's warnings or instructions when using the sealant agent. So
She obviously didn't use the product properly,
that's right.
based on what's transpired in this case. Is that correct, Nunz?
Yeah, but what I found was odd was that she appealed on the basis that the risk of injury was not foreseeable, and I cannot see that on its facts.
No. Well, if there's a warning to say if you don't apply these agents, it becomes an incredibly slippery floor.
And when Mr. Durucci fell, I think her words, quote, "I'm sorry, due to rain, the driveway is very slippery." So
That's right.
that puts you in.
she's aware of it.
Yeah, she had actual knowledge.
And that's, I'm stunned that they would appeal on that basis.
Well, the issue of foreseeability has just gone out the door
Yeah.
when you said when it rains, it gets very slippery.
Yeah.
Yeah.
So it's pretty foreseeable. You
Exactly
actually told them
Exactly.
you're going to fall over.
That's right.
The moral to the story, Jess, don't do your own driveway, I
Yeah,
guess.
pretty much. And just for occupiers to be aware that you are responsible for people coming onto your property and ensuring it's safe.
A lot of plaintiffs in these circumstances probably don't seek legal advice. Would you agree with that?
Yeah, twofold, Tony. One, they don't seek legal advice, and two, they assume that defendants like this won't have insurance, and they say, look, I won't go see a lawyer because they probably don't have insurance. But sometimes, and a lot of the time, they do, and so you've got rights there to enforce. And so it's a lesson to both, I think, from a plaintiff and defendant perspective. One, get insurance, and two, if you do get injured, people do have insurance.
And more to the point, a lot of these accidents happen in circumstances where the people know each other and they're too scared to actually put in a claim, so they're prepared to wear the loss, which is serious damage in certain circumstances, because they're too scared to upset their friend,
That's right.
who incidentally is insured.
Yeah.
Look, I make the comparison to, you get insurance for your car, and if you hit your friend's car, you're going to say, well, claim on insurance.
Yeah,
the first thing
yeah.
you do, and it should be no different in, either your own shop or your home or wherever you are. So it's a barrier that unfortunately some people can't get over.
And the homeowner shouldn't get upset that someone's going to lodge a claim, because the whole idea of getting insurance in the first place is to protect and preserve your position if someone does lodge a claim. Is that correct,
Yeah,
Jess?
that's exactly right, Tony. I mean, that's why the insurance policy is there. So.
And the excesses for public liability insurance are fairly minimal.
minuscule.
They're fairly minimal
Yeah.
when you're talking about the size of these claims, like 121 grand. If you have to fund that themselves, clearly that'd be out of business, but
Yeah.
you don't have to.
Viewers, we've got to go to a sponsors break. Stay tuned. After the break, we'll bring you up to date with a couple more interesting decisions. Viewers, welcome back to the show. The next case is very relevant to everyone out there, because we all seem to take trips overseas to places like Fiji, Malaysia and wherever else. Tell us the facts of Fallen Hillview Limited trading as Outrigger Reef Fiji Resort, Jess.
Yeah, so Tony, what happened in this case was that the plaintiff slipped and fell on wet stairs whilst at the Outrigger Resort and sustained injury. And proceedings were subsequently issued in the New South Wales Supreme Court, interestingly, as opposed to in Fiji. So
Tony, can you do that?
Okay. Well, that's the issue here. What the New South Wales Court has to determine is whether the New South Wales Court is the forum of convenience, which means what, Nunzio?
Basically, is it practical for it to be heard in New South Wales? That's basically what it needs to be heard.
Yep. And what do the judges look at to determine whether it should be heard in New South Wales or Fiji, Jess?
one of the things they'll look at is, I guess, whether they have the expertise in the law, which of course goes without saying they do. And one of the other relevant points, which is relevant to this case, is the availability of witnesses.
Availability of witnesses. There's cost factors that kick in as well.
Cost, expense, suitability of the forum. There's a range of factors that I think the court give consideration to, but in this particular case, the one that the defendant or the Outrigger Reef Fiji Resort was focusing on was an unwilling witness, Tony.
Yep, an unwilling witness, which the court found didn't mean that wasn't prepared to give evidence. And also, what the judge highlighted, Jess, was that these days with digital or visual, audio-visual. Give us a bit more about the audio-visual.
Oh, look, Tony, we've got Skype. So these days you can be in the upper side of the world and still be accessible. So to me, really, I wouldn't surprise in 10 years whether you don't need to rock up to court at that point. So that's just the way of the world. And look, I like the fact that plaintiffs or potential injured people got access to justice at all parts of the globe.
Exactly. And Jess, This particular plaintiff might not only have a common law claim, there could be benefits attributable to an insurance policy, travel insurance.
Yeah, it could be as well, subject to what the terms of the policy are. So that might be an avenue worth pursuing as well.
And Nunz, you see a lot of people travelling to Malaysia, Singapore, Hawaii, Bali,
Yeah.
all the Commonwealth-friendly countries. Well, if they're common law-friendly in the sense that they'll settle by the English, then they've got common law rights,
Yeah.
which means that in all probability you could issue one of these claims in the Victorian Supreme Court. Is that correct?
Exactly right. Look, I said we've got one that we're speaking about offset in Hawaii, Tony, and if they've got, I said, common law principles, then look, the courts of Australia and particularly I think Victoria have the knowledge and know-how to run those matters. I think they're probably the most intelligent bench probably
That's
in
it. That's
the
it.
world. So.
And I guess the issue is they apply the substantive law of the country where it happened, which
Yeah,
in
that's
simple
right.
language means what, Jess?
Well, it just means they look at the law that covers or that's relevant in that particular country and interpret it as you would interpret our laws.
Tony, quickly on the case itself, slipping, obviously around the pool, it's always wet there. What do you think?
Oh, I think you're a certainty.
There's signs up supposedly.
Oh, well, there's those
Does that
Coles
matter?
cases in New South Wales where the sign was right next to the husband and wife when they were arguing, and she said she didn't see it. Yeah, it really depends on the
And
plaintiff's
she
evidence.
still won.
Yeah.
So-
Well, I mean, the plaintiff could say, look, there might have been a sign, I didn't see it.
Yeah.
I mean, it depends on the positioning of the signs and, where you're coming from. Maybe one sign's not enough. You might have to have multiple signs. There's a lot of issues. So, viewers, it's very important that you get the advice of a lawyer. Okay, let's get on to this next case. This is very interesting because it covers issues about what you can claim in terms of loss of income and also Griffiths and Kirkmire, which we'll explain shortly. Taylor and the owner's strata plan number 11564. It's a 2014 High Court decision. You tell us the facts of this one, Nunz.
Yeah, look, the plaintiff's husband was killed when a shop awning collapsed on him, and obviously his wife made a dependency claim. And the issue in this case was effectively how much she could claim by way of loss of earnings by obviously attributable to him when he was alive. And the cap in New South Wales for a plaintiff is 3 times the gross average earnings, but he was earning more than that. And the issue was, did the legislation also equate to a deceased, deceased wife? And what was the result, Jess?
Well, the High Court ultimately found that that particular provision did not apply in this case, which means that the deceased's actual income could be considered and is what equates to the actual loss in this case, which is a great result for the applicant in this.
So let's bring it back to the viewer. What would they
Well,
say?
basically, say for instance the 3 times gross annual amount is say $1,000 a week. He clearly was on a lot more, and what they're saying is that she can claim for whatever he was on by way of dependency payments. So she wasn't capped, which I think is fair because if he was an income earner and she was relying upon that, why should she suffer as a result of it?
Exactly. What about, we've got a similar provision under the Victorian Wrongs Act. Section 28F of the Wrongs Act in Victoria covers this issue of 3 times average weekly earnings. Now, assuming this happened in Victoria, would the decision have been the same, Nunz?
Look, I think it's silent on it still, Jess. So what do you think? I think that we probably would. Consider this is a High Court decision now.
That's
I think that
right.
we'd probably get the same decision.
Yeah, I would agree.
Subject to now future legislation change.
Yeah, I mean, it's an equivalent provision, so you would imagine that if it was before a Victorian court, they would have to follow the High Court decision. Of course, there's other factors that come into play, but...
I agree with that.
Yeah.
But why isn't it the same for... Why does the plaintiff have to be deceased to get that type of access to damages? I don't get, Tony.
This is the facts of this particular case. It's not to say that if it happened to someone that was alive, that you couldn't still argue the
there's
point.
caps, though. That's
I
what
know
I'm
there's
saying.
caps.
So,
But it just shows you that you're probably worth more dead than alive.
the unfortunate
It's
part...
the old westerns where wanted dead or alive, you still get the same amount of money.
But unfortunately, that's how the law provides in
Yeah.
this case.
I was just going to say, Tony, as you mentioned, that's why you've got the Griffith and Kirkmire claim, so...
Yes. What's Griffiths and Kirkmire, Nunz?
Look, we touch upon it in the first segment. Effectively, it's services you receive at home that are effectively administered by other people. So if you used to do the washing, the cleaning, the gardening, but now you can't do it and someone else has to give you assistance, you can claim for that assistance. And as Tony said in the first segment, about $30 an hour.
And Jess, touch wood, assuming you injured your shoulder,
Yeah.
hanging up the clothes, washing the clothes, vacuuming, cooking, blah, blah, blah. Now, under the Victorian legislation, Nunz,
Yeah.
you've got to clock up 6 hours a week
Yep.
over 6 months. Is that correct?
That's the minimum threshold. Get over
Yes.
that, then you can claim indefinitely, Tony.
And Jess, is it fair to say that in a lot of cases, that part of the claim's worth more than the pain and suffering component?
Yeah, most certainly, Tony. I mean, it's a very easy target to achieve. I mean, like you mentioned, it takes me that long to do my hair. You can imagine how long it would take to undertake other tasks. But look, it's often something that plaintiffs don't realise they can claim. So it's really important to keep record of the amount of time they're getting assistance.
It's not capped, Tony.
No.
So
no.
that's why, you know, if you have catastrophic injuries, arguably you will get more than
Yes.
the pain and suffering.
Well, you need to keep a logbook, viewers, and also report it to your doctor that you got other people doing the work for you. Because if it's not corroborated by medical records, it's a question of whether they believe you, which is difficult. Nunz, is there anything else you'd like to tell the viewers?
Yeah, look, this has been an interesting episode about, I think, the rights that people have, and it just shows that you need to see and consult a lawyer because there's so many rights and options out there, and if you don't see a lawyer, you won't know.
Anyway, we come to the end of the show, guys. Jess, thanks for coming on board.
Thank you for having me, Tony.
Nunz, a pleasure.
Thanks, Tony.
As usual.
Cheers, appreciate it.
Thank you.
Viewers, thanks for watching. Go to our Facebook page, go to Twitter, all the social media. Give us your comments. Stay tuned for future episodes, and always remember to stay safe.